Hi, everybody. This is Monty McIntyre, and you are with me on Trial Alchemy today. Trial Alchemy is a podcast that I host, and I've been a California civil trial lawyer as long as my guest, since 1980. I've been a member of American Board of Trial Advocates, ABOTA, since 1995, and these days I help people and help lawyers in these three ways: help them settle cases as a mediator, help them decide issues as an arbitrator, and help them decide cases and issues as a referee. So I do that with ADR services. I also help people keep up with the case law in their practice areas with one paragraph summaries that I call California case summaries. And with this podcast, I help lawyers learn from experts like my guest today, Steve Pasarow, people who've tried lots of cases and people who are members of the American Board of Trial Advocates, and they are the best of the best. So let me tell you a little bit about Steve Pasarow. Steve graduated from UCLA and then went on to Southwestern Law School. He was admitted to California State Bar in 1980. He's been practicing law since then. He's a very highly experienced trial lawyer. He's tried more than 160 civil jury trials, and very, very few people can say that. And in fact, this year in 2025, Steve was the first recipient of the Trial Lawyer of the Year award presented by the Association of Southern California Defense Counsel. Well deserved, but it's based upon not only recent experience, and he's tried more trials in the last 5 years than most people try in their whole life. It's a lifetime of work, and he's still going strong. Now, in addition to being a member of the American Board of Trial Advocates, Steve served as the president of the LA chapter of ABOTA, and that was in 2015. He's also a member of the American College of Trial Lawyers. And these kinds of organizations are invitation-only organizations. You only are invited if you are a person of the highest capability and character. He's also a member of the Federation of Defense and Corporate Counsel, another invitation-only organization. And Steve belongs to many other associations. I'm not going to name all of them. He's also a member of the Association of Southern California Defense Counsel. He's served in many areas of leadership. And in his areas of practice over these 45 years, he's tried all these cases, and his primary areas are automobile accident, commercial transportation, defense of those cases, and civil litigation and defense of those cases. So, Steve, welcome to Trial Alchemy, and thanks so much for being a guest today.
Thank you, Monty. It's a privilege and a pleasure to be with you this afternoon.
Well, let's start with this, Steve. You've been a trial lawyer and you've had a lot of trials. In fact, you're in the middle of a trial right now, as we were discussing a minute ago. You're dark on Fridays. We're recording this on a Friday. So you're still going strong. Tell us about one of your satisfying trial victories. I'm sure you've had many, but why don't you share that with the audience to start?
Certainly, it's my pleasure. This was a trial that I did approximately 10 years ago, and it was in Ventura County against a very capable ABOTA level trial lawyer in Ventura County. And it was a case that we had taken over shortly before trial from staff counsel for the insurance company. It was a very difficult and challenging case. Our client was pulling out across a highway up in Ventura in Somas, which was a country road. It was very dark at night when he began to pull out, and he pulled out in front of a motorcycle who was going in the opposite direction. There was a very significant accident, and the plaintiff was thrown from the motorcycle and alleged that he had a very significant multiple fractures in his leg with significant residual complications. The issue in the case was whether our client had properly yielded the right of way when he began to pull out, and whether the plaintiff was riding his motorcycle too fast for conditions and not keeping a proper lookout. When we got the file, the demand had been steadfastly for the policy limits and it was non-negotiable. When we got the case, I was able to discuss with the carrier that we increased our offer substantially to approximately $750,000 for the trial. The plaintiff attorney acknowledged that that was a very reasonable offer, but he felt that he would be able to persuade the jury for substantially more than even our policy limits, which were $1,250,000. We went to trial, and it was a very challenging case. We were definitely contesting liability. Our client was an elderly gentleman, but his wife was the passenger. And the argument that I made is that there wasn't just two eyes in that car, there were actually four eyes, and that the wife was also actively paying attention to the roadway conditions when they pulled out on that night. And of course, the plaintiff vehemently disagreed. He was a young motorcycle rider and was destined to become go into the fire department, and that would have been his goal, but because of the injuries, he was unable to do so. So basically, we tried that case for over 2 weeks in Ventura, and as I indicated, it was a hard-fought case on liability, and there were issues related to the nature and extent of the injuries, but the injuries were objective, so there wasn't a lot of potential for minimizing or mitigating the nature of the injuries. So it really came down to liability and whether or not we would be able to persuade the jury that our clients properly yielded the right of way and the motorcyclist, the plaintiff, was just simply traveling too fast and should have been able to see us in a reasonable amount of time to avoid the accident. So the jury, the plaintiff attorney argued to the jury that liability was clear and asked for multi-millions in damages, well above the policy limit. So what ended up happening is the jury deliberated and they came back and they returned a verdict of a defense verdict on this case for our client. And obviously the plaintiff attorney and his client were very disappointed about this result, and they actually ended up appealing the case to the Court of Appeal. And the Court of Appeal, we were very grateful, concluded that there were no errors in the record and that this was a factual determination by the jury, and they upheld the defense verdict when we had offered the $750,000 against a firm demand of the policy limit. So when I reflect back on the trials that I've had the privilege to defend during the course of my career, that one certainly is at the top of the list because it was a very difficult, challenging case where we got it right before trial from staff counsel, and it was against a very capable ABOTA level trial lawyer. So that is one of the cases that I think would be worthy of consideration for discussion about what are some of the trials that I find most memorable and most satisfying at the conclusion of the case, and even to this very day.
Boy, you got your client a great result in that case. Congratulations. I mean, you had the lid off the policy, sounds like, and they'd made a under the limit demand, and he wanted to go from millions and millions, and to get a defense verdict, your client must have been so grateful and gratified.
Yes, they were very ecstatic, not only the insured clients, but also the carrier was also very pleased. And as a matter of fact, I still have occasional cases with the claim specialist that was the handler on that case. And inevitably and invariably, we always bring up that case when we're talking about trials and what we feel are some of the great results. And even to this day, we still talk about that case. And one of the reasons I think we were able to prevail is that while our defendant driver was elderly, and especially by the time of the accident had a stroke and was not quite the same person he was when the accident took place, as I mentioned before, his wife was a passenger and she was very alert and a very good witness. And she was that second pair of eyes And the theme that I developed in the case to basically explain was, as I said before, there were not just one pair of eyes in our car. There were two pairs of eyes looking both to the left to determine whether there was any traffic close enough to constitute a hazard. And when they began to pull out across that country road up in Somas, it was safe to go. And then this plaintiff came too fast for conditions kind of out of nowhere, and that's what caused the accident. And I was able to persuade the jury through that testimony and obviously other testimony through reconstruction and engineering that our client had basically properly yielded before he entered the highway, and he was not the cause of the accident. He was not negligent, and the jury found that question number one was whether the defendant was negligent. The answer was no. So that was my theme that I developed during that trial.
Now, Steve, I'm guessing, but you tell me if I'm wrong, that by using that argument of you had two pairs of eyes, I'll bet the wife made a pretty darn good witness and was sharp and believable and probably likable. And that probably helped convince the jury. Is that something that was going on?
Oh, absolutely. It was, and here's what the irony of that is. That when we got the file from staff counsel, the recommendation from staff counsel was to admit negligence because they did not feel that our client was going to be able to hold up in his examination, whether it be in direct or cross. And they weren't too persuaded that the wife, as the passenger, was going to be able to carry the day. And when I interviewed them, when I first got the file, I came to the conclusion that we should not obviously admit liability, but that despite the limitations that our client driver had, the wife was very strong, very adamant, and she just came across as a delightful witness and very energetic, and she was able to, I think, persuasively testify about what happened in support of her husband. And that really, I think, was important for the jury. And that was probably the main reason that I was able to persuade the jury that our client was not at fault, despite the significant catastrophic nature of the injuries of the plaintiff, multiple fractures to his leg, and that he was not able, because of those fractures, to basically continue on with his desire to become a firefighter. And that was significant future damages that were being alleged. And
Right.
that was where they got the basis for the model of the multi-millions in damages, because they also were claiming a loss of future earning capacity for a firefighter. So that was part of their damages model as well. So there was potentially a great risk for this case, but because of those factors that I mentioned, we were able to use those to our best benefit and advantage, and we ended up getting a defense verdict.
Well, one of the things I'll talk about with plaintiff's lawyers a lot is, if the plaintiff is a likable person, that really makes a difference in their side of the case. But the same thing holds true if your defendant is a likable, believable person. That sounds like that's exactly what the wife was. So that likability was a big help for you in that trial.
Yes, there's no question about it. And that became frankly the cornerstone of our defense. And
Yeah.
so I started developing that through voir dire, an opening statement. And that was the theme, was that there wasn't just one pair of eyes in that car, there were two. And
Yeah.
I was able to use that and build on that throughout the course of the trial. And the other interesting aspect of that is that the plaintiff's experts were all very capable and very experienced. And I was able to work through those issues because otherwise, had there not been the opportunity to present the defense theory of the case, this would have been a potentially substantial plaintiff's verdict.
Oh, yeah. It was definitely a dangerous case for the defense. So, Steve, you're
Yes.
in trial now.
Yes,
This trial you've been talking about, with this great result you got in a defense verdict, you've tried over 160 trials in your career. You're
yes.
preparing for trial all the time. I think we were talking in the last 3 to 5 years, you've tried like 20, 25 trials or something, or maybe even
Yes,
more.
actually, I'm very privileged as a defense trial lawyer to have the opportunity to walk into a trial courtroom with these cases that are assigned to us. But a little more over the past 3 years, this trial that I'm in right
Wow.
now is the 20th jury trial that I've been involved and had the privilege to try. So I've tried.
Congratulations.
Thank you very much.
So, Steve, you are often coming in late at the
Yes.
in the case and taking over for staff counsel or other people. But when you know you're going to go try a case and you're doing that final prep work, really getting ready and making sure you're ready for that trial, what's the process or routine you've developed over the years to really get ready so you know you're ready to go when the judge says, let's bring in the jury?
Yes, indeed. Well, it really depends on whether we've had the file from the outset. So we've been able to develop our defenses and experts through our own work in the case, as opposed to when we're asked to take over a case right before trial. So, for example, the trial that I was telling you about, the trial story of that trial back in the day, we had taken it over right before trial from staff counsel. It turns out that the trial that I'm presently engaged in, which is uh, basically a automobile accident case, is also a case we took over 1 month ago from staff counsel. So
Wow.
both those cases, all the experts had already been selected. We didn't have the benefit of being able to use experts that we thought would be appropriate for the case. So one of the challenges that when you get a case from another law firm is basically making sure that number one, that the experts are all prepared and have gotten all the information and materials and have completed their analysis. And you have to thoroughly go through that file to make sure that there isn't anything that's been done through the discovery process that could be a potential surprise or smoking gun that the
Right.
plaintiff attorney would know about, but that we wouldn't just because of the volume of the information that has to be digested in a very short time. So when we take over a case from staff counsel, the first thing we do is we do a thorough deep dive into every nook and cranny of that case to make sure there aren't any surprises. And we begin to marshal the evidence and make sure that the experts that have already been retained, typically they may not be experts that we normally work with, that we want
Right.
to make sure that they are familiar with us and we begin that process of preparation. We counter that with a case that we've had from the outset, that we know what the discovery has been. We know what the discovery responses are. We've already started to develop our theories of the case and develop our themes. So when I'm preparing with our team the file for trial, the first thing that we do is we make sure that we have all the information necessary, all the medical records, all the depositions, that we begin that process then of marshaling that evidence and developing our themes and our defenses. And that's basically what we do as we're getting closer to the file. Because at that point, you've usually on the defense side, we've submitted a pretrial report. There have been multiple conferences with the carrier. We've got
Right.
work with the client, and we also start to begin to work with the experts to make sure that they're prepared for their depots if their depots are going to be taken, or we make sure that they have all of the information and that they are prepared and have the ability to present the case, but also to render their opinions and the basis for them. So there's a different approach depending upon how the file has come to us. And that's basically what we do as we're getting the file ready. So that's
Okay.
how we do it here at KPC.
You got to do a lot of work fast when you take over at the end of the case, don't you?
Yes, and that's true. Now, one of the benefits that we have, Monty, is as you mentioned in the introduction, and thank you very much for that. I'm very grateful for what you said. The fact is that we specialize in the defense of automobile and transportation cases, and I have specialized in that area for my entire career, from literally day one has been auto defense. And so we are set up for being able to basically take a case, and because that's what we do, and we're proud of the fact that we believe we have a reputation of doing it well as a auto defense firm, we're able to basically take that information and basically digest it very quickly because we
Yeah.
understand the case, the type of case, and more likely than not, we've seen similar cases with similar issues in the past. Of course, every case is different, but they all have trends and patterns. And especially when we specialize in this area, we find it's better for us to stay within our expertise so that we don't get involved in cases where we might not have that same ability to quickly marshal the evidence and digest the case and develop the themes and theories. Even though what we typically get are very complex automobile accident cases, whether they have liability issues, mechanism of injury or biomechanic issues, or even the nature and extent of the injury and future damages that are being claimed, we have that ability to be able to work those in to our system with much more dispatch than if we were taking on a variety of different cases, whether they be general liability, uh, premises liability, or other types of cases. So we specialize in one area, and we're very proud of the fact that we believe that we do it well. And that's the
Oh,
reason that we're able to take on these cases like we do right before trial or build up a case and basically set our defenses. And if we're not able to get the case resolved and settled for a reasonable, fair, and objective manner, if we're prepared to try the case to a jury verdict to the best of our ability.
well, you talked about this a little bit earlier in talking about one of your cases, but let's talk a little bit about some trial themes. And I imagine you use different themes depending upon the case and the facts and the issues. But in addition to what you've already shared, give me some example of some other good trial themes that you've found to be pretty successful in your trial practice.
What I'm always been going back in the day, very, very believable in terms of, or believe very strongly in the need to develop a good trial theme. And so I have used in a number of different themes. They're all very case specific, but it all depends on whether or not we have a liability defense or whether or not it's mainly liability is admitted or conceded and we are then trying to hold the damages down. And
Right.
so it just depends on the circumstances of what the case is. So, for example, in the trial that we're currently in, we've admitted negligence, but we're in the process of arguing that the plaintiff was comparatively at fault for the manner in which they entered the intersection when the light changed.
Right.
So one of the themes that I developed and stated to the jury. It's as simple as can be, but starting from voir dire and the mini opening all the way through the opening statement is that the theme is, and I've used this in the past on other similar cases, that if the plaintiff had just looked to their left, this accident would never have happened.
Hmm.
And I keep developing that, and that helps the jury to get an understanding. And so I don't get too bogged down in the minutia, and I keep the themes very simple. Or if it's a liability case that we've basically are not contesting or disputing liability, then we talk about damages and we talk about the theme that while there may have been some injury, soft tissue strains and strains, if the case calls for a case where we can establish degeneration in the spine. Then we talk about the fact that this is a case where the accident may have caused some soft tissue strain and sprain, but basically what has caused the issues related to pain management or surgeries or future care is that it was superimposed on degeneration. And I spend a lot of time talking to the jury about that things are not always as they seem, because this is a case where the defense is established because we can prove that there was degeneration progressing in the spine and that the forces involved in this accident would not have been sufficient to cause any aggravation of that condition. And that's how we proceed. So those are some of the themes, depending upon the type of case that I typically use. And I've got a number of other ones as well, just depending upon certain ones are more fact specific. But those are some of the general themes that I like to use.
Well, great. Thanks for sharing that. And how about this? Can you share a theme, maybe one or two that you've heard from the other side on the plaintiff side, where you said that was a pretty good theme after you heard it?
That's a very interesting question because what I've learned through the practical test of experience with regard to the plaintiff attorneys is they basically have a simple themes. I mean, it depends, of course, upon liability, but a lot of what I've seen the plaintiff attorneys do is that they, through their PowerPoint presentations, which they use, they basically try to establish that the plaintiff did not have any pre-existing condition. They try to minimize through their themes that degeneration could even be a factor. And then they try to talk about the issues related to the defense and the defense experts and the fact that the experts have a bias because of the relationship with the particular firm if they're used in multiple occasions or primarily do defense work. So the themes that I see the plaintiff attorneys doing are basically based on their position of to try to basically refute what our themes are. And
Right.
it's more reactive. And then they try to tell the story about the intangible damages, that how the accident changed the life of the plaintiff and the family, if that's an issue. And they try to use those intangible damages as their theme, that the plaintiff was able to do activities of daily living, recreation activities, work-related activities, but because of the accident, those intangibles now have been lost and are not going to be able to be found because of this accident. And look what the negligence of the defendant did. And then they turn that and then they try to start to demonize the defense. And that's what
Okay.
I've seen.
Well, let me ask you this question I'd like to ask folks, and that is, you're 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 probably one of the most experienced attorneys as far as number of jury trials completed. So this would be good. What part of the jury trial, in your opinion, and based upon your experience, is the most important, and why is that your view?
What I've concluded through many years of being an active defense trial lawyer is that I still am of the belief that the uh, jury selection, the voir dire, and now what we do in the many openings, and then the opening statements are very important for setting the tone, the themes, and the stage for our defenses. I think that we have to be very mindful, especially as the juries and their perceptions have changed through the years, and including COVID. But now we're not seeing the type of jurors from the greatest generation or even baby boomers that we did back uh, in the day, and now we're getting younger jurors. We have the Gen X, the Gen Y. We now have millennials that are primarily on our juries, which are folks in their 30s, 40s, early 50s, and they have a different perception than what the greatest generation or baby boomers did in the day. And so what I've had to do is learn those perceptions and be able to change the way that the cases are presented so that they will resonate more with those types of jurors. So I'm basically not trying cases like I did even 5 or 10 years ago, but I've had to really change the approach. But the one thing that has remained constant is the importance of the voir dire and opening statements in regard to the development of the themes, defenses, the narratives, the facts as we understand them and put them in our chronology, because once the trial starts, it's a little more difficult at times for the jury to follow it. So if you have it all in a cohesive framework in the opening statement, it really helps frame those issues for the jury as they move through the trial. And then, of course, in the summation or the final argument, you can pull it all together, so to speak. But it's
Well,
all
let's
always based on what was initially done in certainly in the jury that is selected, or as it commonly is referred to as deselected, and then you
right.
set stage in opening statement. And that's what I feel is very important to this very day. Even though the jury trial process has changed throughout the decades, the fact is that those key components still remain the same. And now we have, in addition, the development of the mini opening, which is another interesting facet of the jury selection or voir dire uh, concept.
Well, let's talk about these things that are the most important part of the trial. And we'll go through them all, but let me first ask you about this because you clearly have some thoughts on this. In your experience, when we went through COVID and we've gone through that experience of the pandemic, have you seen jurors acting differently after we've gone through the pandemic than you were seeing them act pre-pandemic?
Yes, there's
And
no
then
question
what
about
are
that.
your observations about how they're different these days?
The juries that we find today, I'll say it started the process pre-COVID. So I would say within the last 5+ years, they are now and have been much more unpredictable in the way that they will accept the either the claims of the plaintiff or the defenses that we present, and it's much more of a challenge to try to find predictability in the process.
Hmm.
And what I tell folks that are interested in this is that it's unpredictable, and it not only is for the plaintiff that unpredictability, but for the defense as well. And I'm finding that while there are jurors and juries that still are very open to defenses that we present, there are a segment of juries today that are much more skeptical about the defense. And a lot of that also has to do with the manner in which the plaintiff attorneys are now trying their cases, with the whole concepts of anchoring and asking for significant damages and trying to set the bar of the case so high that it makes it very difficult for the defense, and the defenses that we present and the arguments that we make and the amounts that we contend are reasonable amounts for damages to have those persuasive under the circumstances, which helps explain why it is that we see more the development of what have been commonly referred to as nuclear verdicts, as opposed to what we used to call them back in the day, runaway juries. And
Yeah.
so all those factors come and coalesce together, which makes the process much more challenging. And that's where I believe the study of juries and the techniques that we implement and employ become even more important. So I just do not believe we can try cases like we did before back in the day. And even I have evolved my arguments and my approaches and my themes, and in the way that I just conduct the trial. It's different than when I was a young trial lawyer coming up in the firm and tried cases far different than the way that I'm doing it now. And the fact that I've tried, we're getting much more baby boomer and the greatest generation juries back then. So I was typically the youngest. Now I walk into these courtrooms and I'm typically the oldest person in the courtroom. And that includes even the judge and the juries. And certainly the plaintiff attorneys that try these auto accident cases on behalf of the plaintiff. So I found it to be a very interesting transition. And because of that, that I've grown as a person and trial lawyer in the courtroom. I've changed my style because frankly, I've changed. And so I've had to make sure that my style and my approach and the way that I present has worked through the stages of, shall we say, going through life and a career. And so I've been very cognizant of that for years now. And so because of that, I've now used and implement advocacy techniques and strategies to help reach jurors today, as opposed to relying on what worked back in the past, because those jurors aren't on our juries anymore. So those arguments may not resonate as well with the jurors that we have today. So I've had to really change my approach. And
Give me
that's
an example. Give an example of maybe something where you've changed your approach with the, millennial generation or with Gen Z compared to what you used to do.
the one of the main evolutions that I've had is that I was never really strong on advocate or proponent of PowerPoint. I always felt that um, one can become too tethered to the PowerPoint and that drives the presentation as opposed to the oral advocacy aspect of it. And I was always more comfortable with using an easel and butcher paper and making notes and handwriting on it. I thought that was a more effective way of presentation for me. But I found that as the juries are changing and PowerPoint has become more prevalent, and I can hardly remember a trial that I've had, maybe just a few handful over the past several years where the plaintiff attorney hasn't used extensively PowerPoint in
Yeah.
many phases of the trial, including obviously opening statements and final argument and summation. So what I've had to do is I've had to evolve and become more comfortable in the way that I present and still stay consistent with what my approach is and my style, but also working in PowerPoint to help with explaining to the jury and also images that will help the jury remember certain concepts, whether it be the
Right.
burden of proof, substantial factor, or issues related to theme development. And I think that I don't use it as much as I see uh, the plaintiff's attorneys. However, I do have slides that I use in either opening or in final argument. And that certainly is one change. I still use the Elmo. I still use the butcher paper and easel, but I now use much more mixed media, shall we say. And
Good.
so the arguments that I make are basically different than what I did before in the sense that now juries, because of the issues related to the internet and social media and Instagram and the TikTok and X, we have to get right to the point.
Yep.
Everybody expects that while they watch on TV or in the movies, that the lawyers can present a final argument in 5 minutes because that's what they see on TV.
Yep.
And it certainly is very difficult, if not impossible, for that to occur. But you have to basically really focus your arguments on what is important. And so I've had to learn to do that as well. And my final arguments are probably shorter than they were back in the day because the attention span of the juries has changed as well. And that also goes for examination of witnesses. The
Yeah.
juries, before back in the day, you could have witnesses or experts, and you could have them on the stand for far longer and maintain the jury's attention span. Now, because of the issues that we've been talking about in social media, television and movies and the like, we've got to get cut right to the chase, so to speak. And because the jury's attention span is not as great as it was back in the day. So
Yeah.
I've had to also change my techniques and my style of how I approach the examination of witnesses. It doesn't matter what the witness is, whether it be a party, a lay witness, accident, expert witnesses, it doesn't, medical doctors, treaters, it doesn't matter who the witness is, but the technique has had to evolve and get right to the point sooner rather than later. And that's one thing that has definitely changed in our approach.
Okay. So in doing the voir dire and you're trying to decide who you want to have on the jury, who you want to get excluded, um, what's your strategy these days? What kind of jurors are you trying to get on your jury? With this younger generations, these different people who have different thoughts, and the baby boomers are the greatest generation.
What I try to do is I really try to emphasize the process is what is reasonable and fair and objective. And
Mhm.
that's the ultimate goal. And try to find jurors that are not going to be so quick to judge and make a decision, but to basically allow the process to play itself out and that to be open to our themes of what we're trying to do on our case and to make sure that the jury will at least accept the fact that we do have the ability to present a defense despite what the plaintiff attorneys have already started to do by their voir dire jury questioning about trying to basically find the basis for more significant damages or injuries, and they try to set that bar as high as they can to the extent that the law and the trial court will allow them. It's up to us on the defense side to make sure that we are clearly able to develop our themes and our theories as it relates to keeping an open mind, following the law, not making a quick decision, but allowing the use of common sense, but making sure that at the end of the day, they're going to look at this through the prism of what is reasonable and fair and objective based on the evidence that's presented and the law that applies. And
Yeah,
I spend that's where I spend my time. And the other part of what I do in voir dire is basically just try to get to know who these folks are and what their
right.
experiences are. It's so much of what their drives their decision-making process is not only their experiences, but what they do day in and day out, just their everyday experiences, whether it be in work or in their family lives or their activities of daily living and try to ferret out those issues because that'll also help drive whether there's a basis for challenges for cause because both the plaintiffs and us are trying to get the best jury we can, but we're also trying to save those peremptories when we can as well.
Right. In the many openings that have developed in the last 10 plus years,
Mhm.
what is your strategy when you're given that 3 minute or however long the judge gives you to talk? What are you trying to accomplish in your mini opening?
That's a very interesting question, and I've spent a lot of time studying what the jury consultants and the trial consultants recommend as to how to approach the mini opening because it's more complicated than one might think. And what I have learned, although it's totally counter to what we as trial lawyers try to do, it's better to bring out the facts that may not be the best facts for your case, as opposed to starting out from the outset of trying to make the jury see how great your case is. It's better to say, we've got these issues and to take more of a low-key approach so that the jurors are going to be more open to what their attitudes are towards the defense so that you can determine whether these jurors would be fair and impartial and be suited best for our case. So it's very difficult to do in that 3 minutes. But that's, I
Yeah.
think, for the defense is to try to do that, to not necessarily bring out the strengths of your case, but to try to emphasize what could be the problems or the weaknesses of the case.
Well,
That's the
I think
challenge.
that makes sense, Steve, because you've got a short period of time to pick a jury, and this mini opening gives you a chance to talk about some of the weaknesses, so
Right.
you can maybe uncover there may be jurors who aren't going to be the right jurors, and you may never know if you don't talk about it. So I think you're spot on.
Thank you. And I've spent a lot of time studying this. I mean, one of the things that I take great pride in is that I try to really stay up with what the science is of advocacy, and I not only use jury or trial consultants when the appropriate case, but I read a considerable amount of what the trends are in the trial practice. And so I've had to really evolve on the whole concept of mini opening. Because when I first started doing them back in the day, say in the last 10 years, as you've indicated, uh, it was a much different approach. I mean, first of all, I would usually object. That's the first thing I did because
You
I
probably
didn't
didn't like
think it was
them.
helpful. Yeah, I was not a fan of mini openings and still not necessarily so. And I found that judges aren't really that way either because I think what they found is that the lawyers, whether it be plaintiff or defense, they basically just try to argue their case right from the outset, as opposed
Yeah.
to laying out the key facts, whatever those facts are, whether they're positive or negative for their respective cases. So I used to always object. But once the law changed, where now one side can request it and the court has to do it, I've had
Yep.
to evolve my approach. And it's been a very interesting process for me because as a trial lawyer, I always want to put out our best case right from the very outset. Even when I'm talking to somebody and I'm giving them the elevator version, the 20-second version of the case, and just saying, hey, this is what I'm trying now, and let me tell you about it. Or they say, well, Steve, what kind of trial are you in now? What are the issues? And in about 20 seconds, you should be able to explain your case. If you can't explain it in about 20 seconds, you need to start honing in more on narrowing your facts and your contentions and your
Yep.
themes so you can say it by the time you go from the lobby to the 15th floor of a building. If you can't do it in that mid period of time, you got to go. I always say you got to go back to the drawing board.
Yep. Got to go back. Hey, Steve, one of the things you're pointing out, you're pointing it out beautifully, is trial lawyers have to evolve and they have to learn and they have to grow. You can't do the same thing that you did 40 years ago today. You got to keep changing and growing. But isn't that also great fun because you have to be renewed, you have to grow, you have to expand. Isn't that a something that you find enjoyable about being a trial lawyer?
Well, that's probably one of the main reasons that I've continued to do the trial work that I've done throughout my career, even now at this point in my career as a trial lawyer. And one of the challenges that I so enjoy is the challenge of the courtroom. And part of that is the evolving ways in which I've had to change my approach to the way that I implement trial advocacy and how
Yep.
the art of persuasion. And I remember from back in the day when my dad was not only a great dad, but was a fantastic trial lawyer and taught trial advocacy and entertainment and copyright law for many, many years at Southwestern and Whittier College and McGeorge. So I learned a lot from my dad about the art of advocacy and the approach. And so as I take what and I've had great mentors, Monty. Not only my dad, probably the primary one, of course, but Ryan Knapp and Don Peterson, and there was another lawyer that I worked with at the beginning of my career, Jack Henriksen. They were these were great trial lawyers, and I was so privileged that they took me under their wing and really helped show me the way. But more importantly, talked with me about the art of advocacy and gave me the opportunities to start trying cases.
Yeah.
And that became a very important part of my career because I wanted to be a trial lawyer from after my first year of law school. So I knew what I wanted to do. I basically wanted to be just like my dad. So I wanted to follow his footsteps. If I'm half the man and lawyer my dad was, I've accomplished something in my life. But the point is that I've evolved through that process. So here I am today, and if I saw a video or read a transcript of when I was a young trial lawyer coming up, and now I would see a video or read a transcript of what I'm doing now, it would be far different, I can assure you. But that's what keeps it interesting for me and why I enjoy doing it so much.
Yeah.
Enjoy that challenge. And that's why I keep at it because it's a constant evolution and I enjoy that and I always have. And so that probably helps explain why I try as many cases as I do and I have the privilege of being able to do so. And that probably helps explain it. Because if I was still trying cases back in the way I did in the day, or I didn't really want to change what I'm doing because it worked for me and I'm not sure I want to try any new things, I probably wouldn't be trying a number of cases or even trying them at all at this point. So
Yeah.
that's what has kept me very motivated throughout my career. And that's probably why I am who I am in terms of my approach, my style, the techniques that I use. It's all through a lot of study and preparation. I mean, I just
Oh,
don't
yeah.
go out there and just do it. I really study what I'm doing and I work very hard to develop those appropriate themes so I can do my very best to represent our clients.
Well, that's great. So we've been talking about these important parts of trial, like voir dire, picking the jury, mini opening, opening statement, and we've talked about that a lot. Now let's talk for a minute, not too long, but when you're in the trial, you're going to be doing your direct exam, but there's also the old cross exam,
Yes.
usually almost everybody's favorite. Now, when you do cross exam, do you tend to use the classic closed cross that I would call it, where you're controlling the witness and you just don't give them much room to answer? Or other lawyers, and they're mostly plaintiffs' lawyers, have developed these things that I call more of an open cross, like a Jerry Spence approach, where he doesn't seem to care what the answer is. He's telling a story through the question and he doesn't almost care what the response is. What is the way that you cross witnesses, and what's your approach?
Well, it all depends on, of course, the circumstances in the specific case and who the witness is. But the basic premise that I start with is that cross-examination is my opportunity to testify and to bring out our story, our themes, our contentions, and I believe very strongly in the concept of witness control, especially with expert witnesses.
Yeah.
And I believe strongly in the concept of using short leading questions by building upon every question and trying to tell your story through that witness. And it's very difficult to do, but it can be a very successful approach if you're able to present it that way. Because obviously, when you're questioning certainly expert witnesses for the plaintiff, the most experts are going to be more combative about how they're going to answer questions.
Right.
But I've learned the ability to be able to do what I characterize as an effective cross. Now, because I have so much experience and I know where to go because I always have a plan, Monty, especially in cross-examination. I know where I'm starting and I know where I want to go.
You
And
got to have a plan, don't you,
you
Steve?
have to have a plan, and every witness is different, but it takes preparation. The fact is, Coach John Wooden, the legendary UCLA basketball coach that is known as one of the greatest coaches and teachers, one of his most important maxims was failure to prepare is preparing to fail. And the
Yep.
fact is that I've learned the fact that preparation and having the goal in mind of what you want to accomplish helps shorten the cross-examination, number one. And number two, helps maximize the cross-examination that you do. But having said that, because I have experience, the practical test of experience, I can, as opposed to young lawyers, I can take more risks and know where to go and not to get too stung by it.
You
And
can because
and
of your experience.
I have that experience that I know how far I can wade in before I need to pull back. And or what's commonly referred to as you got to be careful about how you go in terms of what questions you ask because the answer may be a lot harder than the question that you threw. And
Yep.
that's a maxim that is very true. And so I've learned how to make sure that they're not hitting the ball or the question much harder than I threw it. And then it's
Yep.
come right back at me. So I've got to make sure that I can maintain that ability and to pull back when I need to. But when I need to, there are cases where sometimes you just got to go and you got to take a chance. But you got to do it in a controlled manner. And
Well, you got
that's
to do it in a controlled manner and you got to do it in a prepared manner. So, as
correct.
an example, the old wisdom is don't ever ask a question if you don't know the answer.
Correct.
Actually, over time, even though 95 or 98% of the time I think that's the right advice, but I realized in some trials, sometimes you can ask a question because you've thought about all the different answers and there's no good answer for them. And if that's true, if you know the case well enough, sometimes you can take that risk. So that may be an example.
It's a very good example because what I find is in my experience, we as defense lawyers have to do a lot of blind cross. And
Yeah,
then when they're calling up these treaters or witnesses that lay witnesses that we may not have even known about until they land on a witness list, or they're calling treaters that are buried deep on where they've listed every doctor that the plaintiff has ever seen practically, and they're buried way deep, and you just don't have an opportunity to depose every non-retained treater. You're
right.
focusing on trying to get the retained experts deposed. You have to end up developing the skill of a blind cross. And when you're doing a blind cross, we have no idea what the answer is going to be because we haven't deposed them. So
Yep,
that is where the technique comes in, that you have to be real sure about what your plan is and make sure that you ask questions where you have a general idea of what would be the type of answer that you would expect. And if you are going to go and start asking questions where you really don't know what the answer is going to be, that's where you gotta back up and go down a different path because
yep.
that's where you really get hurt. And so I've learned how to do that. And I have approaches that I take and to deal with that. But we do a lot of blind cross on the defense side.
Oh yeah, you do. But I think you're absolutely right that in a controlled cross, you can use that very effectively to tell your story, make your points, and get that point across to the jury. So that's a very effective tool. Well, Steve, this has been a wonderful conversation. It's always amazing how quickly the time races by. But we're kind of at that point where I want to ask you to give some advice to lawyers who maybe don't have that much experience. Maybe they haven't tried any cases or only a few. But what would be your advice to somebody who's interested in becoming a trial lawyer? Maybe you heard it when you were young. Maybe it's just what you've learned over your career. But what advice would you give to somebody who says, I think I'm interested in becoming a trial lawyer?
What I would tell them then is this, to try to join a firm where they actually do jury trials and
Yeah,
then try to determine whether a relationship with a mentor can be made and that try to learn as much as possible from that senior trial attorney work your way up to a point where you can go and second chair or observe trials and then start to learn by doing. I'm a strong proponent in the concept that you can sit and you can watch trials, but that won't help you when you get in there and you have to do it yourself. The only way that you're going to learn how to
Yep.
do it is through study, through preparation, and through getting up there and just learning by doing. And that's what we try to do here. And I think that's where most firms will be able to try to have their young lawyers develop that skill set that they can become those young trial lawyers. And the other concept that I think could be important is in the other side of that coin is that if they really want to do trial work and they're not finding that the opportunities in whatever firm they're in aren't being provided, then consider going into governmental service, whether it be in the district attorney's office, city attorney's office, or
Right.
public defender's office, and spend a couple of years, 2 or 3 years there learning the art of advocacy, and then going back into private practice where you have trials, you've done the trials, and you have that experience, and then you'll be able to go in with having the trials that have been done, and you'll have the opportunity to develop further trial practice once you go back into, shall we say, private practice from governmental service. That's how what I would say. But the other aspect of it is you need to study. You need to read the great trial books and learn from those examples and try
Yep.
to have an understanding of what has been done before, which will help you to learn what you need to do now and in the future. And when I
Yep.
was a young trial lawyer, and to this very day, as I've tried to emphasize in our conversation, I spend a considerable amount of time studying the art of advocacy. And I've done that throughout my career and continue to do it to this very day. So that's what I would say, and that's what I tell our lawyers that come to our firm and they want to begin a career as a trial lawyer.
Well, Steve, thanks for that great advice. Thanks for taking the time to have this conversation. It's really been delightful, and I know the people who listen or watch this are going to learn a lot from you with all the experience. So thank you very, very much for being a guest on Trial Alchemy.
It's my pleasure, and thank you for the privilege of being here to be with you this afternoon, Monty. It's been my pleasure.